standoff between the judiciary and the government over the appointment of judges to high courts and Supreme Court has taken an ugly turn. The Supreme Court Collegium has released publicly the intelligence reports on at least 5 judges who were to be appointed, or at least who were recommended by the Collegium to be appointed to various high courts. And the Collegium has made public their rejection of these intel reports. Now, they vary from being openly gay to having a foreign partner to even expressing one's opinion on social media. Now, this, the government says, will be a matter of discussion between the Collegium as well as the government. But at the same time, the government also insists that the Collegium system itself is opaque. It needs reform, and only judges appointing judges cannot be kosher anymore. At this stage, what's going to give and how? All right, it's now a case of who will blink first. Let's go across to an eminent panel of lawyers who are joining us on this debate tonight. Arima Sundaram is Senior Advocate of the Supreme Court. Aman Lekhi, former Additional Solicitor General. Bishwajit Bhattacharya is also former ASG. And Karun Anandi, Senior Advocate, also joining us. Let me start with you, Arima Sundaram. For the first time, you have the Collegium put on record in public their comments, their rejection of these intel reports. I don't think these intel reports have ever been made public about recommendations of names by the Collegium of lawyers who can be promoted to become High Court judges or judges who can be promoted into the Supreme Court. By making it public, has it got to a stage where the differences between the government and the judiciary on some of these names have become unbridgeable?
Well, I wouldn't say that, because the differences have been there for a period of time, over many years. The Supreme Court has a strong collegium, a collegium which believes in the real doctrine of the separation of powers, that believes that the judgment already laid down by the Supreme Court as to the appointment of judges has to be followed, and the collegium is sticking to the law as has been declared and as prevails today. As to the issue of making it public, I think this goes with the overall increased demand for transparency which had taken place, which resulted in transparency, not now, but over a period of time, on various issues which affected the public, and various issues, whereas earlier the judiciary was considered to be in an ivory tower. It's whatever happened there was meant to be completely opaque. Over a period of time, on demand of the public, and I must say the media, and the working of the media, the transparency has increased. So much so that today, when this is being commented on left, right and center by the media anyway and by everybody else, and on the government side it is very clear that it has been stated why they are saying no, for the Collegium to reiterate and make very correct and bold statements with regard to what was said about both Saurav Kripal and Mr. Somashekar. I think the Collegium is just is applying the law as stands in India, as has been declared in India.
So let's look at these cases individually, and I want to ask Aman Lekhi this. In the case, I think the most dramatic is that of Advocate Saurav Kripal. This was the intel reports objection to him being elevated as Delhi High Court judge. He is gay. He could be biased because of his open support for gay rights. His partner is a Swiss national, to which the Collegium has responded by saying it's unconstitutional to reject the candidature on grounds of sexual orientation. There is no reason to presuppose that the partner of the candidate, who is a foreign national from a friendly country, would be inimical to our country. Many persons holding high offices have foreign partners. Inclusion of Kripal in the judiciary will add to the diversity of the bench. It does seem rather odd and strange in this 21st century where even the Supreme Court had struck down on Section 377 to say that you can't have an openly gay advocate appointed as a judge in a high court.
Absolutely. I mean, the stand the Collegium has taken is unexceptional. I'm surprised at the comment the government gave because what I recollect the letter was that passionate pursuit of gay rights. Now, a lot of energy, enthusiasm, fire is something which is expected of Indians, and we want passionate people on the bench too. Now, pursuit will not necessarily mean bias unless there's predisposition. And in any case, as long as the discipline to keep one's perspective out of an assessment for which there's a legal procedure, merely because you have a view, will not in any way disqualify you as a judge.
Yeah.
Unless, of course, you sanitize minds altogether and scrub them of all content. Each one of us has a view, and the views collectively constitute an ideology. Now, merely because some of us have an ideology doesn't necessarily mean that holding of the ideology disqualifies the person from elevation.
Yeah.
Because an objection to the ideology is equally an ideology. Now, with the objection to the ideology is equally an ideology, the question is, what the Supreme Court says, multifariousness, a multi-dimensional approach, and plurality becomes important because we want all voices on the bench. As long as the legal acumen and capacity is there, insofar as the entitlement to be on the bench is concerned, there can be no objection. And more so, because the memorandum procedure and the Supreme Court itself has ruled, which is binding on the government, as the recommendation has been reiterated, the discretion of the government to in any way avoid, notwithstanding some unhealthy precedents of the past where the Supreme Court itself conceded to the government's demand, it is obligatory that the government does in fact appoint. There have been some chatter about his being the judge of son of an earlier judge and some correlation with the current Chief Justice. What is missed is that the recommendation did not come from this collegium. The recommendation is 2017 to 2018. It's a different scenario altogether. Yeah. And this is a reiteration of the recommendation and not initial recommendation. Okay. So the entry of politics into it and the guise of ideology, both are unsavory. And insofar as the entitlement is concerned, it is unobjectionable.
Okay, let me ask Karunanandi, the larger question that the government has been asking, and we've seen this public sparring between the law minister, some judges who have opined on this matter, is that the collegium system is opaque, it needs reform, whether it's the NGAC or any other form of appointment of judges. The larger question they're asking is if in the US, the president appoints judges and has to be confirmed by the Senate. In the UK, the king appoints judges upon advice by the Prime Minister. India is perhaps the only system where judges appoint judges. That's a larger question that the government is asking. Karunanandi.
We don't have kings in this country. We do have basic rights. And those basic rights have been adjudicated through our constitution, by our Supreme Court and our parliament and our governments, and the law has evolved in a variety of ways. The law as it stands now, as both Mr. Sundaram and Mr. Lekhi have placed, and I agree with them, is that the second judge's case in particular, and now we have, effectively 4 judges' cases along with the NGAC judgment, says that the ultimate decision maker here is the Chief Justice. Has the government upheld the Constitution in this regard? No. Because just in the case of, let us first take the case of Mr. Kirpal. The name of Mr. Kirpal has, the Chief Justice has, and not just this Chief Justice, as Mr. Lekhi pointed out, even prior Chief Justices, have reiterated his name. And now this is the second reiteration. This goes against constitutional norms. Secondly, the law currently under the Nalsa judgment is that, as Justice Radhakrishnan says, is that gender identity is one of the most fundamental aspects of life, and this includes sexual orientation. It refers to each person's deeply felt internal and individual experience of gender, and this includes the protection, expressions of gender, including dress, speech, or mannerisms, right? Mm-hmm. Now, Mr. Kirpal, having he's not someone who he's I think quite private about his life, but the fact that he has not hidden his sexuality, it's a travesty for the Intelligence Bureau to say this. And indeed, it exposes the fact that the Intelligence Bureau cannot speak for the government, and the government must independently apply its mind through the Attorney General. The reason being that the Intelligence Bureau is not rooted either in any statute or indeed in proper norms, because there's a story that's told actually about an Intelligence Bureau report about a nominee who was referred to as boozy in his boarding school. And they said that he's referred to as boozy and he's an alcoholic, and the man was a teetotaler. He'd never touched a drop in his life. So by making these reports public and by making their opinion public, I think the Collegium has taken a step in the right direction. Because what is happening now is a greater level of transparency. It is the fact that the Collegium is standing up to a long-cherished value of diversity on the bench. And it is the fact that, frankly, the IB objections in many, almost all of the cases that I've seen. In fact, I've not seen one objection that seems to be robust.
But here's the thing. We've had these public sort of sparring, if you will, Bishwajit Bhattacharya, the law minister questioning, Collegium, the fact that there is no system called the Collegium as per the Constitution. It was upheld, of course, in a couple of judgments. But as the government says, this is a convenient way. You have every other high appointment in this country, which is vetted by the people in some form, either through parliament or through the elected government. Nonetheless, I'm not getting into that aspect. The larger question, you also had the vice president recently even go to the extent of questioning the basic structure. He says there is no such thing as a basic structure up until a judgment that happened in the 1970s. But nonetheless, the larger question that's being asked is it time for reform of this system? Is it possible that the Supreme Court and the higher judges of the Supreme Court will agree to a system where it's not just 3 judges who decide who gets appointed to high courts and who gets appointed to the Supreme Court, that there will be greater representation in that system? Bishwajit Bhattacharya?
Zaka, the rule of law reigns supreme in India, and the law as on date, as it is, that the Collegium decision after the second reiteration is binding on the government. And unfortunately, government is not complying with the recommendation of the Collegium. Government has been sitting over it. And you talked about, sort of reform. The biggest reform has started yesterday or the day before, when the Supreme Court Collegium, the top 3 judges of the country, emphatically reiterated with the reasonings with the Intelligence Bureau and RAW gave to the government. This shows what kind of total frivolous, insinuations can be made, which has got nothing to do with ability, integrity, and competence of the person concerned. So I personally feel Collegium system is basically evolved from 13-judge bench, Keshavananda Bharati. Then we had S.P. Gupta of 1992. Then we have the 3rd judge's case of 1993 and 1998. And finally the NJAC. In NJAC, Zaka, the world must not forget that the government faced defeat. And the defeat was faced in 2015, 16th of October. So that is the law. The law as it stands today, the government is bound by the law declared by the Supreme Court. Article 141. Article 144 says all authorities, civil and judicial, shall act in aid of Supreme Court. So therefore, I think government has been ab initio wrong. I'm not saying this government or that government. It is basically 2 wings of the state. And you say that the Collegium system is not as per the Constitution. There is a total, if I may say with the greatest of respect, misconception widespread, because the Chief Justice of India has always been consulted, always been consulted in the appointment process. Collegium only impels the Chief Justice of India to consult his colleagues. That is called Collegium. So Collegium does not mean another institution. Collegium means the same Chief Justice of India now is obliged to consult and take the opinion of two senior most colleagues for appointment of High Court judges.
All right.
And for the Supreme Court judges and transfer of High Court judges.
Okay,
so
let me go back to Arima Sundaram on that point. Again, in the cases of Advocate Somashekar Sundaresan and in the case of, I think, Advocate John Satyan, both of it pertain to, quote-unquote, their views as expressed on social media. Now, again, Arima Sundaram, in this day and age, to say that a free citizen of this country cannot express his or her views on social media, that is tone deaf.
I think, if you pardon my saying it, that particular excuse trotted out seems very, very hollow. You know, every judge, every citizen has his own views on various issues. That does not mean that if you're a person who has views and who can have independent thoughts, a thought which maybe does not run with the mainstream, you're not fit to be a judge. I mean, we always know, I've been in the bar for so many years, more than 40 years. Let me tell you that we used to know that there were benches which were very pro-labor. There were other benches which were pro-management. There were some benches which were pro-tenants and tenancy rights. Some which felt landlords should get their lands back. Now, they all had their views. There is nothing wrong. They had their views. But once they sit on the bench, they may have views. And because of those views, they may have certain disposition to a case. But that will not be their decision making. Their decision making will be on the law. And to think that such people are going to be guided by their own views and ignore the law is, I think, pardon my saying it, absurd. Because in other words, what if I take this to its ultimate, I lead to an absurdity that anyone who has independent views should not be made a judge.
Yeah.
Anyone who has who can speak his mind should never be a judge.
Yeah.
Anyone who just does nothing except follow the mainstream should never be a judge. Is that what we are saying? On the contrary, what makes the Supreme Court the great institution it is in India is this divergence of views. This ability to look at a problem from different angles. It's only when you look at something from different angles and not from your own view and your microscopic look, when you look at it in a macro way, that you can really lay down law, which is what the Supreme Court does, the law which applies to the whole of India.
Okay.
And in diversity lies the great union of India.
Sure. So
and if you take away that diversity in thought,
let me go back to
sorry,
Aman
but
Lekhi
it's
on the
leading to an
question
absurdity.
of what will give now, because I think it's got to a point where it's public. There is bad blood between representatives of the government and our higher judges. It's like I said, the sparring has been happening not in the back channels, not behind the glare of the media. It's been happening on the front pages of the newspapers. It's been happening on primetime debates. We're all talking about it. Has it got to a stage where somebody needs to step in and pull back and say, let's take this behind the scenes. Let's sort this out behind the scenes, because it doesn't seem like at this rate, it's become almost like an ego battle. It's become like who's going to blink first, who's going to give.
No, nothing should be sorted behind the scenes. Now that it's out in the open, we have the issues and the counter issues, the controversies in the public eye. The question here is that whatever steps we take hereafter, whatever decision is taken, appointment or otherwise, the reason for the acceptance or rejection is known, which is a very good thing. In fact, the whole objection was opacity, and as far as opacity is concerned, that is out the window, and now you've got transparency.
By saying that views expressed on social media are a bar for someone being promoted, then you're basically saying that his or her qualifications as a legal person, as a legal expert, mean nothing.
What you're saying is a very good point, Zaka Jacob. There's a Harvard study that looks at the orientation of judges after they are appointed to the Supreme Court. And whether they are liberal or conservative, they tend to the middle after they are appointed, which is quite interesting. The experience of being on the bench and of adhering as they must to the doctrine of precedent is something that causes them to move towards the center. Now, in our own legal system, and I think that having looked at Bush versus Gore and other judgments of the United States Supreme Court, that our appointment of judges system is imperfect but better. And Indore Development Authority, which is a Supreme Court judgment of 3 judges, speaks of when a judge must recuse themselves. And I think this applies in equal strength to views expressed prior to appointment to the bench. And what it says is that opinions may abound when you are looking at a particular issue. Mm-hmm. But the point is that do you do your job when you are on that bench and you are hearing a particular case? Do you adhere to the requirement of precedent? Mm-hmm. Do you adhere to the lack of bias? Do you listen as a judge? And these qualities, I think, when you look at some of these candidates, when you see people like Saurabh Kirpal and Somashekar Sundaram and Mr. Satyan, the Collegium has chosen well. And it is now really, I think, up to the government to set this battle of perception at rest, because the legality and the constitutionality is clear.
Okay, we've got to wrap up at that. Thank you very much to all our panelists. We'll see how this plays out in the next chapter. Will the government now put an end to this? Because the ball is clearly in their court. Thank you very much for joining us.
Oh,